Afternoon, everyone. Welcome to this special edition of Healthcare and the ADA Inclusion of Persons with Disabilities webinar series. I'm Pam Williamson, and I am the moderator for today's session. I am from the Southeast ADA Center, and I am a white female, middle-aged, brown with silver highlights, and brown hair with silver highlights and wearing glasses. This series of webinars is brought to you by the Pacific ADA Center on behalf of the ADA National Network. The ADA National Network is made up of 10 regional centers that are federally funded to provide training, technical assistance, and other information as needed on the Americans with Disabilities Act. You can reach your regional ADA center by calling 1-800-949-4232. If you need captioning today, real-time captioning is being provided. The caption screen can be accessed by choosing the closed caption or CC icon in the meeting control toolbar. You can then decide if you want subtitles or the transcript. If you do not have sound capabilities on your computer or prefer to listen by phone, please dial 1-669-900-9128 or 1-646-558-8656. The webinar ID is 865-3219-2796. The passcode is 595267. Please note this is not a toll-free number, and the information has also been put into the chat area. If you experience any technical difficulties during today's webinar, please send a private chat message to the host by typing in the chat window. Type your comment in the text box and enter. You can use the keyboard Alt-H to access the chat box via the keyboard keys, or you may also email adatech@adapacific.org or call 510-831-6714 for voice and relay. This webinar series is intended to share issues and promising practices in healthcare accessibility for people with disabilities. The topics cover physical accessibility, effective communication, and reasonable modification of policy issues under the Americans with Disabilities Act, or ADA. These webinars occur every other month on the fourth Thursday of the month at 2:30 p.m. Eastern Time, 1:30 p.m. Central Time, 12:30 p.m. Mountain Time, or 11:30 a.m. Pacific Time. By being here, you are on the list to receive notices for future webinars in this series. The notices go out 4 weeks before the next webinar and open that webinar to registration. Now, today's webinar is a special session. So it is titled HHS Section 504 Notice of Proposed Rulemaking. On September 14, 2023, the Office for Civil Rights in the U.S. Department of Health and Human Services published a proposed rule under Section 504 of the Rehabilitation Act, which prohibits discrimination on the basis of disability. The proposed rule covers all recipients of HHS funds and includes proposed provisions on medical treatment, the child welfare system, web, mobile, and kiosk accessibility, accessible medical equipment, and integration, along with many other issues. Section 504 and the Americans with Disabilities Act both protect important rights for people with disabilities. And this webinar will talk about some updates in the proposed 504 rule to make it consistent with current ADA rules. The rule is open for public comments through November 13, 2023. And in this presentation, OCR will walk us through some of the key provisions of the proposed rule and share how to comment. You may learn more by reading the fact sheet, Non-Discrimination on the Basis of Disability Proposed Rule, Section 504 of the Rehabilitation Act of 1973. The link is in the chat area. Please note that there will not be a PowerPoint presentation or a Q&A session today. Now, at this time, I'd like to introduce our speakers. Molly Burgdorf is currently a Supervisor Policy Advisor in the Office for Civil Rights at HHS and the team lead on the Section 504 rulemaking. She is an advocate, an attorney, and a woman with a disability. Molly has also served as the Senior Director of Rights Policy with the ARC of the United States, the Senior Policy Attorney at the Center for Public Representation, Senior Advisor with the Administration for Community Living, and Senior Advisor with the Administration on Intellectual and Developmental Disabilities at HHS, among many other roles. We are also joined by John Thompson. John is a policy analyst for the United States Department of Health and Human Services, Office for Civil Rights. He has investigated allegations of civil rights violations in public and private entities across the United States, negotiated settlement agreements, and helped draft regulations and guidance concerning discrimination based on race, color, national origin, disability, sex, and age. Molly and John, welcome, and I'll now turn it over to you.
Thank you, Pam. Good morning or good afternoon, depending on where you are. I'm Molly Burgdorf with the Policy Division in the U.S. Department of Health and Human Services, commonly known as HHS, Office for Civil Rights. I'm a white woman with brown hair, silver streaks in the front. I'm wearing a black blazer and I'm in front of a blue background with the HHS logo. And I want to thank you all for inviting us here today to talk about the HHS Section 504 Notice of Proposed Rulemaking. I'm going to kick it off by sharing some general information, walking you all through some of the key provisions, and then I'm going to turn it over to my colleague, John Thompson, to discuss some of the specific accessibility provisions. So today we're talking about, as Pam has said, the HHS Section 504 Notice of Proposed Rulemaking. And Section 504, as many of you know, and as Pam summarized, is a part of the Rehabilitation Act, a law that prohibits discrimination based on disability by recipients of federal financial assistance and in federally conducted programs. And the proposed rule that we're talking about today covers recipients of federal financial assistance specifically from HHS. I also want to acknowledge that the Rehabilitation Act covers federally conducted programs as well. And the Office for Civil Rights at HHS has committed to also issuing a rule regulating under Part 85, which will cover HHS conducted programs. But today we're talking about just this particular rule, which covers recipients of funding from HHS. And I also want to make clear, there are existing 504 HHS regulations that are still in effect, and we continue to enforce the authorities we're responsible for under 504, as well as under Title II of the Americans with Disabilities Act, which covers, of course, state and local government entities. So if you have a complaint or suspected allegation of discrimination on the basis of disability, you can, of course, contact the HHS Office for Civil Rights. We continue to do our enforcement work, but at the same time, we're proposing to update these regulations to make them even more consistent with existing ADA requirements and for other reasons that we can talk about as we get into some of the key issues that we're covering here on healthcare and other issues. So why are we undertaking this rulemaking now? HHS first published these implementing regulations for the federally assisted programs in 1977, and we've only minimally updated these regulations since then. We've been informed by our own enforcement work, including complaint investigations and compliance reviews. We've received information from stakeholders, including people with disabilities, and we conducted listening sessions with the community early in the process of considering developing this proposed rule. We've also received reports and recommendations from experts, including the National Council on Disability And we've worked in close collaboration with our federal partners, both other agencies within HHS and federal partners outside of HHS, most prominently the Department of Justice. And then, of course, it's important to update these regulations based on changes in health and human services programs and changes in the law since the 70s, which includes the enactment of the Americans with Disabilities Act, the ADA Amendments Act, the Affordable Care Act, the Supreme Court decisions, particularly Olmstead, which we'll discuss later, and other significant court cases. So the proposed rule that we're going to be talking about today is several hundred pages for anybody who's had a chance to review it. We're not going to touch on every piece of that, but I want to highlight some key provisions in the proposed Section 504 rule today, in part because, as you heard, our public comment period is still open. It closes on the 13th, so you don't have much time, but we would really love to hear from the community, and you'll hear this repeated request throughout this presentation. If you think that something goes too far, it doesn't go far enough, we want to hear from you, because we want to make this the strongest and most effective version of these regulations that we can finalize. So I'm going to talk today in conjunction with my colleague, John, about some key provisions that we think may be of particular interest to this audience. That's discrimination in medical treatment, value assessment methods, child welfare, a couple of provisions where we are for the first time adopting specific enforceable standards for accessibility. That's for web, mobile, and kiosk accessibility, and then accessibility of medical equipment. And then I'm going to pivot to some provisions that were intended specifically to make our regulations more consistent with the current ADA regulations, including a discussion of our integration provisions. I had mentioned we'll talk about the Olmstead decision, and it'll be in that section. So I'm going to start with discrimination in medical treatment. And for those who may be interested in commenting, this is proposed Section 84.56. Proposed Section 84.56. The proposed rule prohibits discrimination in medical treatment decisions, including decisions based on stereotypes about a disability, judgment that an individual will be a burden on others due to their disability, or beliefs that the life of a person with a disability has less value than the life of a person without a disability. Why do we think this provision is necessary at this time? Well, we have seen, unfortunately, in the COVID-19 public health emergency, the prevalence of discriminatory attitudes and the related consequences became very clear. For example, in making decisions about the allocation of limited resources like ventilators in the COVID-19 public health emergency, people with disabilities too often were put to the back of the line in terms of eligibility. And this isn't a new issue, of course, but it was something that we saw, again, another example from the COVID-19 public health emergency in the crisis standard of care plans that some states and healthcare systems use to make decisions about the potential rationing of care when resources are limited. And once again, people with disabilities sometimes found themselves at the back of the line or not even included on the list for life-saving technologies and services. We worked on a number of complaints that we had received on that specific issue during COVID, but it's not, unfortunately, a new issue under COVID. It's something that we have seen under organ transplant decision-making. Once again, people with certain types of disabilities who would otherwise have benefited from life-saving organs that they needed to survive sometimes weren't even included on the eligibility list because of their disability unrelated to their potential success once they received the organ transplant plan, but because, for example, the person would be considered not capable of successfully complying with the post-operative requirements to be successful, not considering that that may just be based on sole bare discrimination or not based on the fact that a person can, with certain supports, be equally successful in complying with the post-operative regimens. So we need to be sure that people with disabilities aren't unnecessarily discriminated against in the provision of medical treatment and life-sustaining care. Specifically, we're proposing that in medical treatment, a provider cannot deny or limit clinically appropriate treatment where it would be offered to a person without a disability in similar circumstances. So, for example, what does that look like? It could be, and these are just hypothetical examples, although we've seen too many real-life examples in the enforcement work that we've done and the complaints that we receive, but it could mean, for example, denying a ventilator to a person with Alzheimer's disease who's developed pneumonia, when that's the standard treatment for that condition, because the doctor may perceive that the patient has such a poor quality of life that they won't offer them this basic life-saving intervention. Or, on the other hand, a provider cannot provide medical treatment to a person with a disability when they wouldn't provide that treatment to a person without a disability in the same situation. So, for example, a woman with a disability seeks a prescription from contraception from a provider that would typically provide that treatment, but due to the provider's belief that any children this woman may have are likely to have that same disability, the provider offers only surgical sterilization rather than the prescription for contraception that they would have provided to a person without a disability in that same situation. That may be prohibited discrimination under this proposed rule. Now, I do want to acknowledge, in developing the medical treatment proposal, we worked closely with our departmental partners to create what we're hoping is the right balance between professionals in the medical field exercising their professional judgment and the prohibition of discrimination. And so you will see we have a provision on professional judgment in treatment, and it does permit medical treatment to be denied where there's a legitimate non-discriminatory reason for that denial, where the disability renders the person not qualified for the treatment, where the treatment is outside the scope of the practice of the physician, or where the person with the disability has not consented to the treatment. In those circumstances, medical treatment can be denied, and that would not be considered discriminatory under the proposed rule. Now, as I said, I would mention many times, but I'm going to pause here and recommend, if you have concerns, if you think this is helpful, but particularly if you think this is that we haven't struck the right balance here of interest between patients with disabilities and professional judgment of providers, write in, let us know. We want to get the balance right. The next provision I'm going to talk about is the value assessment method provision, which is proposed section 84.57. That's proposed section 84.57. Value assessment methods can play an important role in determining whether a particular treatment or medicine or other types of medical interventions will be provided and under what circumstances. More and more, we're seeing value assessments being used to calculate cost-benefit decisions in healthcare. And what are we talking about? How are these value assessment methods used to make a decision about whether treatment or medicine may be provided and under what circumstances? It can be just a bare cost analysis, but it also can be a consideration in things like whether a prior authorization will be required. So after your treating professional, for example, gives you a prescription, whether you have to go back and get an additional authorization from your health insurance company before you have access to that medication, or whether you have to go through step therapy, meaning you have to have your current treatment, whatever your prescription, for example, that you get from your healthcare provider, that's the medication that they've selected for you and think best treats whatever condition that it's prescribed for. Step therapy requires that you fail at less expensive or alternative treatments before you are allowed to actually access the medication that your provider has identified is the appropriate one. So it's how many hoops you have to jump through before that you get access to the care that you need. But it can also be a bare cost, meaning that some treatments are more expensive, some are less expensive. Value assessment methods can discriminate against people with disabilities when they assign a lower value to extending the life of a person with a disability compared to the value of extending the life of a person without a disability. And what we're proposing to prohibit is when recipients of federal financial assistance from HHS use methods that discount the value of life extension on the basis of disability when they're providing or withdrawing benefits or services. What does that look like in practice? Well, it's hard to find a perfect hypothetical here, but for example, a recipient uses a method whose mathematical formula places a lower value on extending the life of people with disabilities versus extending the life of people without disabilities. And so a person with a serious lung disease wouldn't have access to a drug that allows their condition to be stable and would extend their life, while a non-disabled person would have access to a similar drug that prevents them from ever developing a life-shortening disability, and they get access to that medication. That could be an example of discrimination in the use of value assessment methods. But we do want to be clear, we are not seeking to ban any particular measures. You will see a discussion in the preamble, which is where the proposed rule talks about what we are proposing to do. And then it's followed by regulatory text, which is the specific requirements that we're putting in place. In the preamble discussion, you'll see a discussion of QALYs, quality assisted life years, which is one particular measure that some communities have found to be potentially discriminatory. We want to be clear, we are not banning the use of any measures. We are only looking to ban discriminatory use of a measure by a recipient, but not the measure itself. And we are also, I had mentioned, it prohibits recipients from using these methods to discount the value of life extension on the basis of disability when providing or withdrawing benefits or services. The when providing or withdrawing benefits or services means you can use these types of value assessments for academic reasons. It becomes potentially discriminatory under this proposed rule, where you're actually making decisions that impact the care that a person with a disability may receive. So that's withdrawing benefits or services, when it actually makes a difference in the kinds of services or benefits that you get. You can still consider these methods in a general application, but when it comes to how they actually play out, when it actually impacts cost-benefit decisions in healthcare in the ways that we've talked about, prior authorization, step therapy, and cost, that's where it can potentially run into problems with violating this proposed provision if it is discriminatory on the basis of disability. I know that one is quite a mouthful, but wanted you all to have a sense that we're trying to get at value assessment without banning any particular use of specific measures. And that's another area where we absolutely do need to hear from you. If you have a concern that this goes too far, or if you think we need to do more, please weigh in. The next provision I want to talk about is child welfare. This is proposed section 84.60, proposed section 84.60. Now, as we talked about up front, we have existing 504 regulations, and the department clearly already prohibits discrimination on the basis of disability in all of our programs and activities, but that includes child welfare. But we're aware that there's been a lack of clarity about these requirements among some organizations when it comes to child welfare. We know that because we have already participated in public voluntary resolution agreements, we've provided technical assistance, we've provided guidance, and we still continue to see the types of discrimination that are very troubling in the child welfare system. For example, hypothetically, but we see real life examples of this too often, removing a 2-year-old daughter from her parents at the hospital because both parents are blind, without the child welfare entity doing any analysis of the ability of the parents to actually successfully parent, and without providing accessible support services that are typically available under the child welfare system in a way that parents with disabilities can have equal access. So we're proposing a provision to address discrimination on the basis of disability in child welfare services, including in removals, including in parenting classes, including reunification services. What we're trying to do is ensure that parents, children, and other qualified individuals are not discriminated against just on the basis of disability in child welfare programs. And that includes decisions based on speculations, stereotypes, or generalizations that a parent, caregiver, foster parent, or prospective parent, because of their disability, cannot safely care for a child. We also cover children with a disability under this proposed child welfare provision. And we also have a subpart that covers parent evaluation procedures. So to make sure that where a recipient is using some type of assessment to make a determination about the parenting abilities of a parent with a disability, that these are tailored to assess specific areas of disability-related needs and not merely based on, for example, sole IQ. You can't use a parenting evaluation procedure that inherently discriminates on the basis of disability. We would love to hear from you if you think that what we're proposing sufficiently addresses the types of discrimination that we're seeing. If you have suggestions about more specific areas of discrimination in child welfare and broadly, and anything else you think we need to address as part of this proposed rulemaking. And at this point, I'm going to turn the discussion over to my colleague, John Thompson, to talk about some of the provisions where we are adopting for the first time enforceable accessibility standards. John?
Thank you so much, Molly. Yes, as she mentioned, my name is John Thompson. I'm a policy analyst at the Office for Civil Rights. I'm 32-year-old male with dark brown hair, a short beard, and I'm wearing a dark gray jacket with a white shirt. So I'd like to talk to you all just about two specific sections that we're proposing in this regulation, both of which would include specific accessibility requirements that can be measured. The first one deals with website, mobile apps, and kiosk accessibility. This is specifically because, as Molly has mentioned, the first Section 504 regulation for HHS was implemented in 1977, kind of long before any of this technology existed. So we really need to get into this space and start regulating it. And those advancements in technology have created, huge differences in the way we deliver healthcare in particular. I think just based on my experiences, and I think probably a lot of your experiences, it's been a little while since I've actually paid a copay in person. I always seem to get an email before or after an appointment asking me to pay online. I know there are numerous mobile apps to, view your health chart, to make those payments. And it seems every time I go to a hospital, there's a kiosk there. And they ask me to check in at the kiosk instead of going to a desk. So there have been some key changes in the way we access healthcare, and we want to make sure that basically people with certain disabilities are not being left behind. Another aspect I want to mention is obviously things like telehealth and basically talking to your doctor over the phone. Obviously, those existed before the COVID-19 pandemic. But the pandemic really, increased the usage of telehealth. With telehealth exploding, we really need to have some parameters in place so that everyone, who chooses to use telehealth can actually access it, especially those who are deaf or hard of hearing. So that's kind of the background, but the next question is, what are we proposing to do in this regulation? So specifically, we have proposed a general non-discrimination requirement for kiosks. Basically, we're saying if a healthcare provider uses a kiosk in some aspect, whether that's for a person checking in for an appointment, to just provide general information, or to procure certain services, we're saying that that kiosk has to be accessible for people with disabilities. We are not suggesting a specific standard for kiosks, in part because we know the US Access Board is working on their own proposed rule for kiosks, and we do not want to undercut them or get in front of them in any way. But generally, we're saying that kiosks must be accessible, and in instances where for whatever reason they cannot be made accessible, we're requiring that the provider make sure that all those same services are provided, by a person, basically a receptionist or someone behind the counter who can actually do the same services. Then for web content and mobile apps, that's where we are going to require a specific accessibility standard. So for those, we're proposing that recipients must comply with the WCAG WCAG 2.1 level AA standards. The WCAG standards are pretty common throughout the globe. Quite a few states have requirements for WCAG. I think the European Union has a requirement for WCAG as well. And we're requiring that basically the web content and the mobile apps of our recipients of HHS funds must be accessible within either 2 or 3 years. And that 2 or 3 years difference depends on whether the individual is a large individual with more than 15 employees or a small individual with 15 or less employees. So that's a whole lot there. I just want to go through a list. This is not, an exhaustive list, but it's a few things that will not be allowed under this proposed rule. We would prohibit providing videos that are not captioned. You cannot use online applications or forms that are incompatible with screen readers, voice dictation, or hands-free devices. You can't use a telehealth platform that does not permit the addition of a sign language interpreter or does not allow for captioning. You can't just use a staff telephone line, even if it's 24 hours a day, instead of having this accessible web content. That's not the same access. Except in very limited circumstances, you cannot just create a separate scaled down accessible website for people with disabilities. You have to make your actual web content accessible. And you cannot link to third-party inaccessible websites where the use of those websites are necessary to participate in the program. There are a few exceptions to this proposed rule, and I really do urge you, if you have any interest, to kind of read these in full. I'm just going to go through these very quickly. There is an exception for some archived web content. So that's content that was basically posted in the past. There is an exception for some pre-existing conventional electronic documents, though there's a carve out in that as well for documents that people are still required to use to access service. There's an exception for certain content posted by a third party, but that's once again only if that content is not required to use the service, as well as linked third-party web content. There are also a few exceptions that we have for post-secondary institutions, which are institutions following high school, like colleges and universities, and similar exceptions for elementary and secondary schools. And these exceptions are pretty much the same for both. It's essentially where in those institutions they use a password protected class content. There are some exceptions there unless the school knows that a person with a disability is taking that class. And for those of you who have read through these or have read through the recent Department of Justice Title II Web Access proposed rule, you'll notice these rules are very similar. And that is by design because we want to make sure we're working with Department of Justice to have similar requirements. We want to speak as one voice. So that's why there's some pretty big similarities between our two regulations. Okay, and I'm going to move on. So the next section I'm going to talk about deals with medical diagnostic equipment. So what we have seen a lot of at OCR is that there are barriers such as in doctor's office, like exam tables that are not height adjustable, mammography machines that require a patient to stand, and weight scales that don't accommodate wheelchairs. And obviously, there are issues here for people with mobility disabilities. Excuse me. And we want to make sure that in our proposed rule, we address these issues. So we are proposing to require that recipients, they adhere to the accessibility standards that were created by the US Access Board for medical diagnostic equipment. And these are standards that govern things like the height adjustability of exam tables, for example, certain transfer services, just making sure that people with disabilities, especially adults with disabilities, can, for the most part, transition on or to these accessible pieces of medical equipment. And I mean, I think the majority of people with physical disabilities that limit their ability to use this equipment know this all too well, but we've heard many firsthand stories from people with disabilities of being forced to forego, a necessary medical examination, sometimes for decades, just because they can't transfer to the right surface, they can't get on a weight scale. We know some women have for decades kind of avoided just a normal gynecological exam because there's been no way for them to get one. So we really believe that this is an important area that we need to address. And just some of the nuts and bolts of what we would be requiring. We would require that newly purchased, leased, or otherwise acquired medical diagnostic equipment should comply with these standards. And then basically all new equipment would comply with the standards up until the entity purchasing the equipment reaches either a 10% or a 20% threshold of accessible equipment. And that depends on the specific type of doctor's office or hospital and what they do. We would also require that hospitals and other facilities with multiple departments that use this medical diagnostic equipment disperse it in a manner that is proportionate by department. Another big thing that we're requiring is that within 2 years, most doctors' offices and similar medical facilities will have at least one examination table and at least one weight scale that is accessible. So regardless of whether they kind of intended to get a new exam table or weight scale, we would require that they get one within 2 years. There are some limitations to this, similar to other areas in Section 504 and the ADA. We will not require recipients to take an action that would result in a fundamental alteration or in undue financial or administrative burdens, though we think that will be a very high bar to clear. We don't think that there are many, if any, recipients who can claim that getting one accessible exam table and one accessible weight scale would be undue financial burden. We will also require that staff are trained to assist with the use of accessible medical equipment, especially in instances where the patient, either because they cannot or they choose not to, needs assistance transferring onto the medical equipment. And just one key takeaway I want to mention as well, kind of regardless of whether a recipient does acquire accessible medical equipment, each program or activity that they run that uses medical equipment must be readily accessible to and usable by individuals with disabilities. So even if for some reason they avoid getting the accessible medical equipment because of undue burden or something along those lines, they must still provide, an accessible program overall, which means finding some way to give the correct health care. And with that, I will turn it back over to my colleague, Molly.
Thank you so much, John. And I do want to mention before we move on, for those who may be, fingers crossed, reading and submitting comments on the proposed rule, you can find the web, mobile, and kiosk accessibility provisions in subpart I, and you can find the accessible medical equipment provisions in subpart J. You'll see that they're quite lengthy provisions where we ask a bunch of questions of readers, so they're their own separate subparts when you review the rule. And now I'm going to turn to, we had talked up front about many provisions of these proposed regulations that are designed to be consistent with existing ADA protections and existing ADA regulations, particularly Title II, which covers state and local government entities. And I'm going to start with integration. I thought this audience might be particularly interested in the ways that we are proposing to align the Section 504 rules covering recipients from HHS with the ADA Title II regulations. So we're proposing a section on integration. This will be proposed section 84.76, proposed section 84.76. And of course, the current 504 regulation includes an integration mandate. It's been there since the 70s that covers services, a requirement that services be provided in the most integrated setting appropriate to the needs of a person with a disability. What we're trying to do here is align the existing regulation with case law and existing DOJ guidance on integration and provide more details about what it means. So the proposed rule specifically incorporates principles established through the Supreme Court's Olmstead decision and other significant court decisions. So we are putting some flesh on the bones of what it means to be a most integrated setting appropriate to the person's needs. What are we actually proposing? There's an application. This provision, like most of the ones in the proposed rule, apply to recipients of funding from HHS. We prohibit discriminatory action, which means that you may not administer a program or activity in a manner that results in unnecessary segregation of people with disabilities. That's discrimination under this proposed section. And then we add some specifics. So we define a segregated setting. A segregated setting under this proposed rule is one in which people with disabilities are unnecessarily separated from people without disabilities. And it goes into some more detail about what may constitute a segregated setting. A segregated setting may be populated exclusively or primarily with individuals with disabilities, may be characterized by regimentation in daily activities, lack of privacy or autonomy, and policies limiting visitors or limiting individuals' ability to engage freely in community activities or manage their own activities of daily living. So for those who are familiar with the ADA Title II Olmstead guidance from the Department of Justice, these align with the principles that have been enforced by both the Department of Justice and HHS as we have investigated and made findings in Olmstead investigations, but now we are officially incorporating that language into a regulation. We also include a provision with more examples of discrimination on the basis of disability in the integration context. So we have a non-exhaustive list of actions that may lead to unnecessary segregation. And I do want to flag that we make clear that people with disabilities don't have to wait until the harm of segregation results in institutionalization. They can assert these protections to avoid unnecessary segregation. So this covers actual segregation, but also serious risk of unnecessary segregation of people with disabilities. And some examples of discrimination on the basis of disability in this proposed section include establishing policies that limit or condition the access of persons with disabilities to the most integrated setting appropriate to their needs, providing greater benefits or benefits under more favorable terms in segregated settings than in integrated settings. So, for example, if a recipient provides respite care services to families with an individual with a disability in nursing home, but doesn't provide services, respite services for families of people who receive services in the community, that may be a violation under this proposed section on integration. Other examples include failing to provide community-based services that result in institutionalization or serious risk of institutionalization. So the proposed provision tries to give a more concrete understanding, both so recipients of funding understand what their obligations are, but also so people with disabilities have some specific information about where they may be able to enforce these rights. What does it look like? We want to give specifics to point to in terms of being able to make sure that your rights are protected. And we think that spelling out more specifically what it means will be helpful on that front as well. I do want to flag that though it's not included in the integration section specifically in the rule, the NPRM also includes a definition for most integrated setting. It falls in the proposed definition section 84.10, which is a definition for most integrated setting that's consistent with what's how the Department of Justice has defined most integrated setting in their Title II guidance. And in this case, we're proposing that most integrated setting means a setting that provides individuals with the opportunity to interact with non-disabled persons to the fullest extent possible, is located in mainstream society, offers access to community activities and opportunities at times, frequencies, and with persons of an individual's choosing, and affords individuals choice in their daily life activities. So it isn't only about the physical structure of where a person is living or spending their days, but it's about their activities and ability to make choices in those settings. There is also a pretty lengthy discussion of civil rights obligations as distinct from Medicaid law and regulation. So just want to be clear, CMS funds most of the home and community-based services programs through waivers under the Medicaid program. That is still true. We aren't making any changes to the underlying Medicaid law, which is based in the Social Security Act under this proposed rule. But we are being clear that where CMS may say that a certain program or activity is consistent with the CMS regulations, that's not enough. That doesn't automatically mean that you're free and clear under the Section 504 proposed rule. That's a separate and distinct civil rights determination. And I know that has caused some confusion. We can see from some of the comments that have come in. So just wanted to be clear that discussion is about giving some background about how home and community-based services are funded, but the independent obligation under civil rights laws not to discriminate remains in place. And in fact, we're trying to be more clear about what that may mean in practice. And then finally, I wanted to turn to a category of key provisions that we're incorporating from the ADA, or we're revising our language to be more consistent with the language in the existing ADA regulations. And these are in many ways required by the legislative changes since the department's original 504 regulations. We're also wanting to make sure that the recipients of funding from HHS aren't confused, because most of them are also covered by the provisions of the ADA. So we want to be clear, we want to use consistent language. Courts read the ADA and 504 together in many cases. So we want to make sure that we are appropriately aligning these regulations with the ADA requirements. So there's many provisions in this area as well. So I'm not gonna even call out the specific section numbers because there are many. But some highlights that we thought might be particularly of interest to this audience include we're incorporating the expansive definition of disability under the ADA and the ADA Amendments Act, mostly specifically in line with what the ADA already uses as their definition of disability, but we are also including long COVID in the list of physical and mental impairments, because that's something that we have looked at closely. We've issued guidance on the issue in conjunction with the Department of Justice, so that there's a clear understanding that long COVID may be a disability if it meets the other elements of the definition of disability. But in most other ways, the proposed definition is exactly identical to what is in the language of the ADA and ADA Amendments Act. We're incorporating specific provisions from existing ADA regulations, including the maintenance of accessible features, the requirements around service animals, the requirements around mobility devices, and the requirements around communications. And as John flagged specifically in the medical diagnostic equipment discussion, we're actually broadly incorporating the limitations of fundamental alteration in the nature of a program and undue financial and administrative burdens where appropriate, so that those same limitations that exist under the ADA will also be incorporated into the 504 regulation, again, where appropriate. And just to speak broadly about the alignment of 504 and the ADA, we want to improve consistency. We want to be sure that we're incorporating the major judicial and legislative developments that have happened since the 70s. And we want to be sure that we are helping folks understand their obligations. And like all of the provisions that we've discussed thus far, this is an area, particularly for this audience who are experts in the requirements of the ADA and the ADA regulations, to weigh in where you think something departs from the existing ADA regulations, where you think it's a mistake, or there's something that you want us to change. We'll consider that. This is an area where consistency is helpful, but you'll notice in some of the small deviations from the ADA requirements and the DOJ's ADA regulations that there are some places where we think the specificity of the HHS activities may need a little bit of tweaking, or some differences may be appropriate. And we do want to hear from you if you think that there are changes or tweaks that are needed. But again, as I said, there's a lot here. I didn't touch on illegal use of drugs. I didn't touch on personal services and devices, but take a look at those provisions and see what you think in terms of what we proposed, and if you have any suggestions or modifications that you think need to be made for HHS recipients. And then finally, we want to talk a little bit about the process. So the NPRM was published, as Pam mentioned, on September 14th. There's 60 days to comment. We're coming to a close now. So I'm grateful that you all had an audience, invited us to have an audience with you before the comments close, but you don't have much time. They close on November 13th. And we can only accept comments until, I think, 11:59 Eastern Standard Time. So if you are planning to comment, please make sure that you get your input in before the comments close, because we cannot consider anything that we receive after that time. What are the steps that happen after the comments close? So we'll be working towards publication of a final rule. Once that happens, we propose that the effective date of all of these new requirements will be 60 days after the final rule is published, with the exception of some provisions, particularly where John discussed the new proposed accessibility standards. We're building in longer timeframes for compliance, and we shape those by the size of the recipient. So sometimes there is more time for smaller entities, and that's a place where we definitely welcome your input. If you think that the timeframes are too forgiving, meaning we're giving folks too long to comply, or if you think that more time is needed because it's too burdensome on folks that will be having to change their practices or change the actual equipment that they have, we do want to hear from you about if we've hit the nail on the head or if you would recommend something different. And then you can, we've gotten questions about when this all will happen. We can't comment on that specifically now. Of course, we know that the comments will close on the 13th. How long it'll take us to get from there to a final rule, we can't say today, but we recommend that you can follow updates in the unified agenda, which is the department's best projection of what we're doing on the rulemaking front. And we will certainly try to accomplish it as quickly as we can. And with that, we will close. But I once again want to encourage you all to please comment. We want to hear from you. We need to hear from this community to make sure that we're striking the right balance. And we look forward to partnering with you on continuing enforcement of both 504 and the ADA. And thank you to Pam and to all of you for your time.
Well, Molly and John, we are very grateful for you sharing this important information with us today. We do appreciate your time and knowledge that you have shared. Now, I want to remind folks, as Molly has said, if you would like to submit comments, the information has been put in the chat. That will be done at the Federal Register, discrimination on the basis of disability and health and human service programs or activities. And those comments must be in by November 13th. So at this time, we are going to close our session for today. So again, thank you for joining us, and we look forward to having you join us for our new series that will start in in February. So we will talk to you then. Take care.